It is our pleasure to have my Lord's esteemed presence illuminating us on this topic. Now, I would like to request Advocate Shri Atul Pandey Sir, President of High Court Bar Association, Nagpur, to welcome our keynote speaker, Honorable Shri Justice Vinay Joshi Sir, with a sapling. Thank you, sir. As affirmed by Roscoe Pound, the law must be stable, but it must not stand still. On August 11, 2023, the Bhartiya Nagrik Suraksha Sanhita Bill of 2023 was introduced in the Lok Sabha for the first time in proposal to repeal the Code of Criminal Procedure 1973. The primary objective of the repeal was to call for a comprehensive review of our criminal laws and adapt them in accordance with the contemporary needs and aspirations of people of India. The focal point of this move was to ensure that our laws provide for speedy justice to all and to overcome the colonial laws. The new legislation provides for the use of technology and forensic sciences in investigation, furnishing and lodging of information, service of summons, among the other aspects through electronic means, making it more convenient and accessible. Specific limitations have been prescribed for time bound investigation, trial, and pronouncement of judgments. The concept of zero FIR has been introduced. At this moment, I feel there is no reason to introduce Honorable Justice Shri Vinay Joshi Sir to one and all, but today I take this as my privilege to introduce my Lord Shri Justice Vinay Joshi. My Lord was born on 24th November 1962 at Pune. Lordship completed his schooling from Solapur and graduated from Shivaji University, Kolhapur. My Lord pursued LLB Generals from DAV College, Solapur, and LLB Specials from Shahaji College, Kolhapur. My Lord has practiced on civil and criminal side at District Court Solapur from the year 1986 and later on joined the judicial services as civil judge in May 1992. Lordship has served as ad hoc district judge, city civil judge, principal district judge at Buldhana, Thane, and Ahmednagar. My lord also served as registrar, inspection, and officer on special duty at High Court, Bombay. My lord was sworn in as an additional judge of High Court of Judicature at Bombay on 11th October 2018. Greek philosopher Socrates said four things belong to a judge: to listen courteously, to answer wisely, to consider soberly, and to decide impartially. I'm sure everybody present here would vouch that my Lord Justice Joshi truly embodies the above qualities. On this note, I would like to take this opportunity to request our esteemed keynote speaker, Honorable Shri Justice Vinay Joshi, to address all of us on challenges under changed criminal procedural laws, Bhartiya Nagrik Suraksha Sanhita 2023. My Lord, over to you.
Very good evening. I deem it myself to be honored for participating this lecture series. I must be thankful to Mr. Mirza and Mr. Pandey requiring me to go through the new provisions because they are all new introduced laws are new for us. Thus, the size of today's gathering itself shows that everybody is eager to know what are the niceties. So, I too now the topic today is a new it is learned that this is a first lecture in respect of this new law introduced. Now, legislatures have done their job now. They have passed in the both houses of the parliament these new laws, and they have been introduced from 1st July. There is a lot of criticism on this. We will come one by one, and majorly we will see what would be the difficulties and challenges which we require to face. Now, there is also criticism that legislative procedure has not been followed. The law was not placed before the law commission. Only three members committee was formulated, out of which one was lawyer, and without approval of the consensus of the entire house, when some members were large numbers were absent, law is passed. That is criticism. Apart from the politics, we are not in that. Now it is a law. It is for judiciary to implement with the assistance of advocates, and the executive have to implement. Now it is a law of the land. So we have to be well equipped and find out what are the ways where there are glitches in the implementation in new law, and how to overcome all these niceties. Now, you see, the laws were very old. Lord Macaulay framed IPC 1874, frankly in 71, Evidence Act. Now hundreds years have series of judgments are there. So many case law is already developed. In all these procedural aspects, there is, you could find now case laws now on your fingertip. All these websites there is available of case law. You just put a section, you will get it. But now it is getting difficult. It will take some decades to overcome and get the ready-made material which you have today on the old existing law. Now, these two parallel legal systems will run hand to hand for few more decades. As you know, that last section of the CRPC, I may say for convenience, because I am prone to say that this, that is BNSS 531, which is a saving and repeal clause, which is very essential. That is has saved all old actions, all old orders passed under this statutes. All sanctions are given, proclamations are issued, everything is saved. And now the crimes which are registered from the 1st July, they have to dealt with entirely with this new BNSS. The old law, you will find that some FIRs are registers, investigations are going on, and some trials, appeals, they have to be followed by old procedure code. So there is a clarity to that respect. Always, whenever there is a law, it shall have a prospective effect, penal statute, because it should be in consonance with Article 20 of the Constitution. So it is the constitutional mandate that one could be punished for the offense on the date what was the offense in the statute books. You can't punish him by subsequently introduced a law. Even as regards to the fine is concerned, that should be in existence on the date of commission of offense. So for all old acts, it is a saved by this specific section 531. Now the problem is that interchangeability. Now there is a criticism that there is a lack of transparency. Then there is a lack of infrastructure, because in the newly introduced law there are so many facets where vast use of technology, video, audio, and their savings, transferring the data, saving, how to transfer it to the court, where it is to be stored, everything has to be mandated. For some of the aspects, the new law has given a 5 years time to the state government to make a infrastructure, logistic is to be provided. But during intergenium period, what is to be done, that is not clarified anywhere. Now, another criticism is a excess power to the police. So you find in most of the cases, there is a drastic change. The powers of police have been enhanced. There is a criticism that it would violate our personal rights. Always any law which is framed by the legislature shall pass the test of the constitutional mandates. There should not be any violation of fundamental rights, because article 20 and 21 are the hearts of our criminal jurisprudence. So if there is a violation, certainly those laws have to be challenged. You see that there can't be any random challenge to this all procedural law, but as and when you experience some glitches or some unconstitutionality, then case to case basis it will come to the constitutional courts, and it will take some time to from the high courts and supreme court the settle the dust. So it is a long process. Now most of the new generation and the lawyers are there. It is easy for you in the sense that we people, we are in the field for 20, 30, 40 years. We are prone to the old sections. The students who have not studied at all are very fortunate, because we have to forget 498, 302, 307. Everybody, it is by heart to us. But now everyone has to, now we all are brought to the square one. Everyone has to read the book. Tomorrow some mail applications come, somebody will say it is 367 of the BNSS. Again, judge, everyone has to read the book, what is 366. Then we will understand, okay, this is 307. In our mind, like learning and French and Spanish language, we have to, in our mind, you convert it in our own language. That process will go on for some time. But now your slate is somewhat clean. Now there is no point of confusion, but still you have to study and understand the old provisions also, because now due to saving clause, this will go hand to hand for near about 10 to 20 years. All trials will go, appeals will be continued, and so we have to simultaneously also see what are the differences in both the statutes. By and large, the provisions are same. There are some changes. We can roughly say that 80 to 90% provisions are the same. But endeavor was made to have a motto to be a speedy trial. Article 21, it is a right. It is speedy trial is a, now it is recognized as our fundamental right. Now to achieve this vowed object, most of the provisions have been made, but roughly 80% provisions are same, but entire chronology arrangement has been changed. So that will create some confusion. If all these provisions are to be introduced in the old statute, there will be hundreds of amendment, A, B, C, D. Wherever there is amendment, you have to insert the section to somewhere. Now a proper grouping has been made. Offenses, there was grouping, but some sections and provisions were scattered. They have been brought under one head. So during course of time, we will get it very easier. Fast and effective justice is our main object of the criminal jurisprudence, and to achieve this, many provisions we can see the color in each of the provisions which newly introduced the provision. The ultimate aim is to give us speed up the trial, and also various rights have been given to the accused, protection of the accused, protection of the victim, and more emphasis is given to the transparency also. You can see that various provisions have been made to audio video recording. So most of the time we have experienced that there are some dying declarations, some 164 statements have been recorded. The judge suspects, did it really? Because there is a cross examination, it is suggested, no, the magistrate has not recorded, I mean executive magistrate has not recorded the statement, it was tutor at the instance of so and so person. So there is some doubt it raises. But if it is an audio video recording, like the cases of search and seizure also, The search was not taken. You know, Section 27 search, whether it is a real disclosure made by the accused while in police custody or it's a farce created. The line of cross examination is on that point. So if there is a video recording is available, then there is a certainty. But again, the aspect of tampering, proper preservation, storage, transfer, everything will come, for which uh, I personally feel that there should be rules are to be framed properly, how it is to be done. And the main difficulty appears to be ignorance of the implementing agency. The police are not equipped. A head constable used to register FIR. Now only modernization is that by use of computer they used to instead of writing they used to print it. But again we find that just name it change, entire 161 statement is the same. But now these methodologies and recording of camera mobile camera is also permitted. Then under evidence act some provisions have been made that how this data is to be collected. Earlier only 65B certificate was enough. Now hash value is to be corrected. Now most of the people don't know hash value. Apart from police, we judges and advocates are also not knowing. The you people knows better than us regarding hash value, how it is to be collected, how it is to be taken. So these are the difficulties. The state have to provide the infrastructure, and during course of time it will happen. Now Mr. Jaltare has handed over me one comparative chart very nicely prepared by one advocate Kothari. Uh, and my sister colleague Falke madam has also prepared one. But I prefer to highlight some key distinction factors and on the point where we have to rethink and we have to explore the possibilities and what would be the difficulties which we will face. I have culled out some major differences in old and new statute. One by one I will tell, and on some crucial aspects we will have some deliberation more. Now, uh, classes of courts have been modified. As you know, metropolitan area as well as metropolitan magistrate as well as assistant session judge post has been abolished. You know, assistant session judge means where a judge of lower cadre has been promoted as a district judge. Initially, he has been appointed as assistant session judge. What is the difference? There is a difference of powers. Unless the powers of additional session judge has been confirmed to him, he cannot try the cases which are punishable more than 10 years imprisonment. Now, if the post of additional assistant session judge is deleted, now is it that everyone will get on first day power to try 302 case? That is not explained anywhere. Maybe I heard that some mechanism will be developed at our state level that for initial 6 months, even though he is a additional judge, he would not be assigned to cases of such 302 or serious cases. So again, it has to be modularized. How to it is to be worked out, because this was the intergenium period, so that during that period, assistant session judge will learn, and after 6 months after delivering, now it is a norm of 15 or 20 session cases, and thereafter powers are confirmed. Again, there would be have to work out what would be the mechanism, or first day he would be allotted. Then district level prosecution monitoring committee has been proposed under section 20 of the new act. Earlier this was not the mechanism. There was a only one director of prosecution sitting at Mumbai, having control on all prosecutors all over the state. Now district level committee has been, the committee has an assistant and other what are the qualifications, they have also been spelled out in the new BNSS. It has a good impact that district level, if the committee is constituted, they have to monitor the progress of investigation. So from the stage of investigation, their intervention is there. That is why the rate of acquittal, which is now at very high, we can say the rate of conviction is just ranging near about 20%. So it is a good step that there would be monitoring from the prosecution side. Then the provision is made about the offences which are punishable up to 3 years. There would be no arrest unless the offence is cognizable, unless it is permitted by the superior officer in case of these offences. So there is one rider put that it is not a discretion of police, he has to obtain permission of superior officers. So there little bit power has been curtailed to that effect. Now there is a one provision has been added about handcuffing. We are coming to that because it's important, touches into our constitutional right. Section 43 has been introduced, which has authorized the police to handcuff. Now, there is a very progressive change about service of summonses. Now, through electronic mode, summonses and warrants can be served. Now, the act has provided that registers are to be maintained. Now, end to end, how it is to be secured, then what constitutes that it was delivered to the proper person, or which uh, are we equipped that accused are having email addresses, witnesses are having that there are problems are coming. When we enter in it day to day, we will have to face some problems for which there would be solutions. But this is a good step because most of the cases we find that witnesses are willing, but due to overpressure, police are not capable or position, or they don't have time to go and serve the summonses. If these services of modern technology have been used, at least 50% people will come at time, and that will help us to speed the trial. Then there is a uh, provision has been made about attachment and forfeiture. That was now the property of a absconded accused who has ran over to abroad can also be seized. That new power has been instituted where we have friendly contractual relations with another countries. We can even forfeit the property abroad. This is a new step they have taken. Then uh, even before conclusion of trial, the property can be forfeited. That is a new amended provision introduced, which was not earlier. So objections would be heard. Police have to go to the magistrate and see that this is a seizure. We have forfeited the property. Now pass the orders. If nobody appears, even before conclusion of trial, such type of orders can be passed under new statute. Under maintenance, law of maintenance, as you know, 125, some a little amendment has been made to ease the agony of deserted parents. Now they can file a petition of maintenance at the place where they stay. That's a good step that poor persons are not required now run only on the count of jurisdiction. Wherever they reside, they can file it. That is a taken care taken about these old aged people. Then a provision is made that every citizen is bound to follow the orders of the police, of course lawful orders, to subserve the aims of the procedure. So it was not earlier. Now this obligation is cast on every citizen. That is a new step taken. Then important, very important provision is preliminary inquiry at the hands of police for the offences in between, having punishment in between 3 to 7 years. We are coming later on to some little extent because it's a very, very progressive step and it has large repercussions. Rather, to my mind, speaking for myself, it's giving absolute power to the police. There is maybe repercussions that the police may be in position to negotiate with the accused, and lot of things will happen. It will be, of course, has to be tested on the touchstone of constitution. Then we will deal after a short while about that power. Then certain protections are given to the public servants. If the private complaints have been filed, the protection to the public servant, that report has to be called from a superior. That was not earlier. Then in private complaint, a valuable right is given to the accused. Earlier, because pre-cognizance stage, there was no locus standi to the accused to appear before court and resist the action. They can do so, but in revision or appeal, because if the process is issued or complaint is dismissed, revision comes to the court. If complaint is dismissed, accused was not heard, but after hearing the complainant, if the magistrate dismisses the complaint and complaint comes into the appeal, revision, then accused has a right to resist what is the favorable order passed him. But till date, before magistrate, before pre-cognizance stage, he has no locus at all. Now, in cases of private complaint, that right is given to the accused. The proposed accused is to be served by notice. The magistrate will hear him and then take a call whether process is to be issued or not. This is one another step which is having also effect on some areas, because it will delay the private complaints. Care is taken that nobody should be falsely implicated, but simultaneously uh, it will have a repercussion that now each magistrate is burden of 5,000, 10,000 cases, and now they will linger for this. Issue notices to the accused. Accused will not appear. Unless accused is heard, you cannot proceed further. These are the practical difficulties which now pose to our system. Now, uh, about recording of statements under 164 by magistrate. Now, earlier, as we experience, whenever police finds it appropriate, they used to take the witnesses to the magistrate and record their statement. What's the use of that statement? That's a different question. Just for a corroboration, we use in criminal trials. But now, in the cases which are of serious nature or relating to sexual offences, now it is a mandate of law that the statements of witnesses must be recorded through the magistrate. It has a great impact, because as we see that in trial courts, 50% witnesses turn hostile. That percentage will be drastically reduced, because there is a mental pressure on him that we have given a statement before magistrate, it was recorded, how it would be used against that he doesn't know. So it is a good step that most of the statements now you will get 164 statements parallel. Again, as a practical, we will find some difficulty. There is 161 statement is recorded. It is an exhaustive statement. In this house, I can say that it is dictated by police. Most of the statements are stereotype statements. But when 164 statement is recorded, it's having a different shade, because magistrate used to record. For magistrate recording statement, he has to drive away everyone. Only whatever the witness says, he used to take it down. Then again, there is a confusion. There would be inconsistency in that. The defense had, because as a matter of right, accused is entitled to have copies. Of course, after filing of the charge sheet, he will get the copies of 164 statement. So the lawyers can take benefit of that. Read 161, 164, put the inconsistencies to the witness, and but anyway, that is the provision. Then now the period of police custody, that is mostly criticized issue of the entire court. Earlier, now the law has been changed. What Supreme Court in Anupam Kulkarni says, that it is a clarified that police custody shall be given in only for 15 days. 15 days, there is no issue. 15 days is remained as it is. But it was in first 15 days. Whatever you want, you may take in piecemeal, 3 days, then to judicial custody, then again 2 days. But after first 15 days, there would be no police custody. Now it has been changed. It is depending upon the period of charge sheet. In serious offences, the period of charge sheet is 90 and other 60 days. Now in the cases where the charge sheet is to be filed within 60 days, you can obtain police custody for within first 40 days and other first 60 days. So it is an interchangeability. So it has some repercussions on your personal, on your, I mean, on the rights of accused of his personal right of liberty also, that we will elaborate after a short while. Now, earlier, if accused is absconding, then charge sheets are not filed. The police are waiting for accused, and whenever the presence is secured along with charge sheet, because magistrates are insisting, go bring the accused, we are not accepting the charge sheet. Now, the specific provision is made that even if accused is not there, magistrate cannot refuse the charge sheet. So now that gray area has been clarified. Now in sexual offences, we have experienced that a poor lady or a child through her mother used to file a police report. Then they doesn't know what happened about that. But now the statute has cast a responsibility of a police to keep the victim informed. After 60 days, they have to inform the victim or the complainant what is the progress, whether investigation is complete, whether charge sheet is ready, is it filed or not. So this new provision has been made to keep the informed. This is a victim centric provision has been made. Now for further investigation, under section 173(8) of the CRPC, the police are empowered to carry further investigation. But now there is a slightest change. If you want to carry further investigation after filling of the charge, you have to seek a permission of magistrate. What I feel that this somewhat curtails the powers of the police, because under 173(8) there is no limitation. Even as per my understanding, permission of magistrate was not required. It is magistrate has to just inform that we are carrying further investigation. Till judgment, they have right to carry further investigation. But now, as a mandate, after framing of the charge, if they want to carry further investigation, because different shades during the investigation will be open. Sometimes some new material they would get, and if they want to put it against the accused, then each time they have to rush to the magistrate, seek the permission for further investigation and do that. That is a new one addition, rather curtailment of the right of police. Then sanction to prosecution, there is little change. Under section 197, we have to obtain permission of sanctioning authority to prosecute. Now a deeming provision has been made. If you have applied for the sanction and within 120 days sanction has not been granted, it is having a deeming effect, that sanction is granted. So it has eased the agony of the complainant. As you know, it is our common experience that people used to write for sanction, nobody bothers to see your application. That's an agony of our system. Higher officers never, apart from the issuing sanction, since inception they started to deny that we didn't receive application, show acknowledgement. But now this is a very good step. So the real culprit is to be booked, and this is a provision which will help the complainants. Now, in complaint cases, as we said, notices to be issued. This is total departure from the law declared by the Supreme Court in Lalita Kumari's case. We will come to that within short time. Now, there is a slight change in the joinder of charges. Earlier, three offences of similar kind within 1 year could be clubbed together in one trial. Now, the number has been increased to 5, so that 5 offences committed within 1 year, that would be brought under one trial. Now, certain timelines, various timelines have been imposed in the new statute. One important one is pertaining to the discharge. If somebody wanted to file a discharge application, he has to file that discharge application within 60 days. If it is a session triable case, from the date of committal of the matter, and if it is a magistrate trial from the date of the receipt of the police papers within 60 days, and thereafter he can't file a discharge application. Vis-a-vis, there is a corresponding duty on the magistrate or judge to pass an order within 60 days. Now there is line of decisions, discharge can be claimed at any time. What about that? That there is no clarification, and there is no in the sense that what is if this timeline is not followed, whether magistrate or judge has discretion for some or some reasons to condone the delay, accept it or not accept it, that will be gradually these problems will be developed. But if there is a genuine difficulty, the accused is paralyzed, he can't, or he was at a foreign country and he come before court and say that for this 60 days I was not there, so it's not my fault, what can I do? Or I was in the jail, I was handicapped, because as you know, lot of exemptions are given to the inmates to protect their rights. So these problems will come. Then the some provisions of plea bargaining have been modified. It has made some ease under section 265A old, new, I don't know, new section. Now, what in some cases there is a minimum rider of sentence. Minimum rider means the magistrate can or judge can punish him not less than 3 years, not less than 5 years. If such a cases comes for plea bargaining, then earlier at least if bargaining comes to success, at least sentence shall be reduced to one half of the minimum. Means if there is a minimum rider of 3 years, then it would be 1.5 year. Now it has been brought to one third, and in other cases 1/4 would be the minimum punishment. Now it has brought down to 1/6, so as to promote the plea bargaining. These welcome steps have been taken. So far as the compounding offences are concerned, section 320 in our code, we expect that there would be some other provisions would be added, but there is no change. Absolutely all the sections are same. Perhaps everybody was waiting for 98 is going in that schedule or not, but now there is absolutely no change. The same section 320 is brought by naming it other sections. Then there is a provision that documents scientific evidence, investigating officers' evidence, technical evidence, or medical officers' evidence can be proved by successor. This is a very welcome stage, because in sessions trial, what we experience, the officer who carries the investigation or the doctor who has conducted autopsy, they have been transferred or not available, not traceable, because again the route is delay, because after 5 years the trial comes for hearing before court. By the time the officer has gone, now it is not necessary to call that officer. His successor in the office can prove those documents. That very novel amendment is made that will help a lot to speed up the trials. Then on withdrawal of prosecution, earlier there, under section 321, there was no right was given to the victim, but now a right of hearing is given. That's a slight and welcome change to protect the right of victim. Now, states have been directed to formulate witness protection scheme. That is a welcome state, because as you know, in serious offences, most of the accused will get benefit, because trial are mainly delayed by the accused deliberately to see can we pierce the witnesses. That was one of the reason. But now there is no protection to the witnesses. Some witnesses, if related witnesses, they used to stick up because their kin is murdered, but some other witnesses, they have nothing to do with this. So under pressure, they used to turn hostile in the courts of law. That is why now these states are framing witness. This is the mandate and directions are issued. Now each state will come with a witness protection scheme. Now it will help to strengthen the prosecution wing. Now, so far as commitment of sentence, some modifications have been made, so that the jails would not be overcrowded. Like earlier, section 436A was there. If one half punishment has undergone by the under trial prisoners, he is entitled for bail. Now that proportion has been reduced by category wise sections. Now in 438, that is anticipatory bail, earlier there is a provision of interim bail, but now we couldn't see such a provision in this. This would be a lot of question of debate. It's not my view, but I say that whenever you have a power to decide finally, you have a power to pass all interim orders. But again, it will take some time to settle all these issues. These are the broadly modifications made. Now, I will just focus and highlight on some issues and the problems relating to that. First, everything begins with the registration of crime. Now, uh, irrespective of a place of offense, it is a mandate on police to register a crime. Earlier, it was not the provision. Earlier, though there is a no provision in the statute books to register FIR if it is outside jurisdiction, police by a practice they used to register a zero FIR and send it to the concerned police station. It was a practice being followed. But now that rider has been removed, irrespective of jurisdiction, it is a mandate on police to register FIR. Now, if it is registered, they can investigate. The situation is very difficult if somebody in Madurai has committed offense, came back to Nagpur and filed at Lakadganj. How Lakadganj police will investigate? That's a problem. Whether they will go there, where are the witnesses? Crime scene, after how many days they will go there? And there is no change in a place of trial. Corresponding provision is not there. Now, any police can register offense, can investigate, but again they have to revert back for a trial to that, because the place of trial, that section has been exactly taken down in the new provision. So, no corresponding amendment. So, it will create some confusion. uh, then this ambiguity has to be removed, whether they can investigate or again they have to revert to register it just for the sake that section is made, we are registering it and sending it again. Probably that would be the wise course, but modulities have to be framed. That the major change is about registration of crime, that discretion is given to the police. The section new section says that if offense is punishable in between 3 to 7 years, then it is a power given to the police to see whether prima facie case is made out. If prima facie case is made out, with permission of the higher officer, they can make an investigation. Of course, time rider is there of 14 days. They can investigate within 14 days, means investigate, I mean preliminary inquiry, and then take a call whether to register FIR or not. Or if police found that prima facie case is there, they will directly register FIR. The question is whether police are capable, whether the discretion is given to the police to decide prima facie case. It's the job of judiciary. The judge has to decide whether prima facie case is made out or not. Now this vast power is given to the police. Now it has very bad repercussions. Now it's a whim of the police. It depends who comes to the police station for registration of FIR. If he want to please the complainant, he will immediately register, skip the preliminary inquiry, because both options are given to him. And if he want, the accused is a rich person, and for some or other reasons he don't want, then he will make a inquiry and conclude, because law authorizes him, conclude that no prima facie case, I won't register. That's totally against the Supreme Court directions of 2014 judgment. Lalita Kumari says that preliminary inquiry would be in only 4 or 5 exceptional contingencies. That is a matrimonial, commercial, or delay, or medical negligence only. But by and large, it's a mandate on police, because 154 earlier section says that when the police receives an information regarding cognizable offense, the law doesn't say it's credible information or reliable information, just a cognizable offense information is there, it's a mandate of police. Now that law has been diluted by this new provision that it will be a matter of debate for years together. Now, uh, then another provision about the power to arrest. This is in consonance with that, but power to arrest and need to arrest are two different aspects. It's not necessary that you have a power you have to arrest, because it's touching to the his very personal right to life and liberty. So, whether these provisions will stand to the touchstone of constitutional mandate, that time will see. In private complaints, as I said, that private complaints, now this is the right given to the accused. Issue notice, hear him. Now you see, the police has power to decide prima facie case, but magistrate, he can't do that. Magistrate has his, there is a fetter on his power. Unless accused is heard, he cannot pass a order of issuance of process. This is the dichotomy in this, because the powers of magistrates are curtailed. On the other hand, powers of police have been increased. That will be also a matter for discussion. Earlier, then the law of sedition, section 124A, what we call Deshadroha, Rajdroha, that has been stayed by Supreme Court. Now the matter has been referred to 5 judges bench and it is pending. It was a stand of government before Supreme Court that don't hear that matter. We have passed a new law having a parallel provisions. Now the, but that has to be decided, because the old cases which are registered under 124 has to be tried as per the old code. Now the question is that now various provisions of MOCA, that is organized crime, and one new species is created, petty organized crime, for a chain snatcher or all these things. A provision has been inserted, like all provisions, similar definition of terrorist act, which is defined under section 15 of the this UAPA, has been brought now in the penal statute. Now the question is, those statutes are there only, they have not been deleted, but this organized crime and terrorist act have been brought into the Indian penal code, now BNS. Then what about those laws, whether police should go to that law or this law? You see that on special statute, there these are some stringent provisions. For these stringent provisions, there are checks and balances inbuilt in that statute. A sanction is required. If search is to be taken in particular manner, that search has to be taken. The higher police officer has to carry the investigation. These are the checks in those statutes, but nothing is there now. All these, even mere suspicion of insurgency, you can put it anyone behind bars. So now these aspects will take a long time to settle down. Then coming to the aspect of handcuffing, under section 43(2), now under certain categories of offences, a power is given police to handcuff, considering the nature and gravity of the offence. Supreme Court in Premchand Shukla's case has deprecated, this is not a criteria, gravity of the offence. Merely looking to the offence, you don't handcuff him. Look to the accused, whether he is a violent. So in exceptional categories, they have to be handcuffed. And the law in DK Basu and Batra's case, 1980, it has been Supreme Court ruled that it is against the human dignity. Don't handcuff. If somebody is paraded, it violates his personal right. But now we have been brought back to 1980 era, again by this giving an absolute power to the police. You see, it is said that repeater offenders have to be handcuffed. Just take an example. If a husband is there, 498 is there, 494, two offences, handcuff him. Is it appropriate that it will be tested at the testing of time? So handcuffing, and where the presumption of innocence goes, because he is an under trial prisoner, if you are handcuffing him and parading him, that's absolute violation of the fundamental rights, which, to be candid enough, which I feel. Then police custody remand, as we said, there are lot of problems on bail now. Now there is a proviso is made, 140 section new proviso made, that police custody, requirement of police custody is no ground for denial of bail, but that's just an exception. But now what will happen? Police will take, with, because first 60 days he can ask police custody at any time. First 4 days they will take a police custody, then he will go to judicial custody. Then the accused may be pressurized, give a confession, otherwise I will again seek police custody. There are lot of things. Just use, imagine what would be there, because in the present system, after 15 days there is no question of police custody, he will be in jail. But again he would be threatened, some statements would be extracted under section article 20. Nobody can be compelled to be witness. Now there, these provisions, there is a fear that it would be violated by such. And now the work of court would also be doubled. You see, if accused after 4 days he is released on bail, again police want police custody, then naturally they have to rush to the magistrate, ask for cancellation of bail. Again it will take time. If bail is cancelled, again PC, again another bail application. So it's a duplication of work, and again it will come to the revisions and high court and all these things will come. But the right of bail, which is also, as Krishna here said, bail and no jail, that principle that will be tinkered. And when you tinker a small comma or full stop in the sections, then again it's a matter of interpretation. So it will be a matter of concern. Now, again, the work of cancellation of bail, then under trial prisoners, some laxity is given. uh, Under trial prisoners, now the period is reduced. Now earlier, if one half sentence has gone, now if one third he has undergone in specific offences, he can be released on bail. Now it will be a progressive step, so that the people cannot be languished behind the bars. Now, certain timelines have been given, various timelines have been given. Now, these different timelines for charge sheet, for seeking discharge, but for some of the timelines, what is the repercussion if not followed? That has not been explained. Whether our system is capable enough, logistic is there to follow the timeline. The courts, the number of courts are static. If you ask the court to decide this within 5 days, it's for people it is very good, looking very good. The timeline within 3 months, decide it, within 6 months, decide it. It's in consonance with Article 21 speedy trial. But is it, can we do that? That's the question. Merely by imposing and creating a picture that we have finished the trial within 2 months, 3 months, because such a parallel provisions are there in various statutes, DB Act, 125, Negotiable Instrument Act. Timelines are already given. We know that nobody bothers for that, because our courts are heavily burdened. So the care is to be taken up in that regard. Now a new kind of punishment has been inserted in the form of community service. But for what it is alternative, that is not given. And what is community service nowhere defines. Only says that judge directs the accused to make a service which will benefit the society. Again, there is element of differentiation, arbitrariness. For some ex-accused, one will say just write essay. For another, we will so go and clean the latrine. That will happen. Some rules have to be framed. So these are by and large gray areas. I have made endeavor to go through by persuasion of my brothers. Now ball is in your court. GP is also there. I am scared about it. So we can discuss. Okay, thank you very much.
Thank you, sir, for enlightening all of us today. I'm sure your guidance will positively be of aid to all of us and the practicing advocates and the budding advocates as well. As my lord has rightly pointed out that our new laws consist of savings clause which aids in administration of justice. They help provide clarity to the procedural laws. Limitation of technology in regards to tampering of evidence and procedural persists. And provision about handcuffing has also been added. Provisions regarding the statement of witness must be recorded by the magistrate has also been added. The provisions of police custody and plea bargaining have also been modified. There is no provision for interim bail which may cause delay in the process. The provision of registration of crime only in case prima facie case is made has also been added, and various other provisions regarding petty organized crimes, sedition, prejudice acts, handcuffing, etc. have also been added and modified in the new act. Now, I request Advocate Firdoz Mirza, Sir, convener of Study Circle, to present a souvenir to Honorable Justice Shri Vinay Joshi, sir. Thank you, sir. As we approach towards the conclusion of this knowledgeable study circle session, I would like to call upon Advocate Shri Akshay Sudame, sir, co-convener Study Circle, to propose the vote of thanks. Please, sir.
Honorable Shri Justice Vinay Joshi and respected members of the bar, on behalf of Team Study Circle and the Executive Committee of HCBA, I extend my deepest gratitude to my Lord Justice Vinay Joshi for sparing time from his busy schedule to be amongst us today. My Lord's enlightening address on the challenges under the new criminal procedure laws, especially on the Bhartiya Nagrik Suraksha Sahita, has definitely helped us gain invaluable insight into this new dimension, which has become an urgent need of the hour. I also take this opportunity to thank the government leader, Advocate Devendra Chauhan, for gracing this function. My sincere gratitude to all senior and junior members of the bar who have joined us today. I express my deep appreciation to Mr. Ravindra Sadrani, Registrar Administration, as well as members of the registry for making High Court Auditorium available to us. The members of print and electronic media have always supported us in all our endeavors. Last but not least, I thank each and every one of you and hope that you all continue to share your support in all our future ventures of the study circle. Before I part, I must inform you that this marks beginning of the lecture series which the study circle intends to conduct. This being the first lecture in that series. Thank you very much.
Thank you everyone for coming here today. I request the dignitaries on the dais and the learned members of HCBA to join for high tea. Thank you.